Welcome all. Tomorrow is a very auspicious day, the birth anniversary of Dr. Babasaheb Ambedkar. It's great pleasure to our bar in association to arrange that we are arranging lectures today on the topic of Indian Constitution. On behalf of Bombay City Civil Court and Session Court, I would like to welcome our today's speaker, Mr. SC Chaturvedi. I would like to request Honorable Secretary to give bouquet to Honorable Speaker, Mr. Chaturvedi. Before starting of the lecture, I would like to give some introduction of our speaker. This SHRI Puneet Chaturvedi. He's belonged to the family of lawyers for 4 decades. Sorry. He has been practicing as an arguing counsel for the last 34 years, appearing in the Supreme Court on behalf of India as well as various high courts across the India. Besides the practicing in Bombay City Civil Courts, he has taught law in University of Mumbai, in Government Law College, Churchgate. He has been regularly invited by the various law colleges. He has writes legal articles and columns in the magazines and websites. His article and speeches are widely held. SHRI Puneet Chaturvedi has also been addressing the annual law training and lecture series conducted by the Bar Council of Maharashtra and Goa on the Constitution of India topic. He provides free legal aid and argued several public interest litigations. He has addressed different medical forums and medico-legal topics. He has been addressing and enlightening the several professional forums, institutions, colleges, corporates house, or bar association of various subjects of law. Interesting, he is talked about attended the judiciary also. SHRI Puneet Chaturvedi has also been appearing in the law expert in the property show of NDTV. And is invited by different television channels also on the topic of various legal aspects. Interestingly, Mr. Puneet Chaturvedi is also noted scholar of ancient Indian scriptures like Ved and Vedant, Upanishads, Puran, Bhagavad Gita, Ramayana, and has developed the extremely lucid and pragmatic applications deriving from the Ved and Vedant. His discussions on the logical interpretation of Ved and Vedant, Bhagavad Gita, Ramayana, and other ancient scriptures and organized across the India and abroad. He has conducted the Vedantic workshop in the schools, colleges, management, and institutions. He has also written articles on Vedantic principle, and he is ably assisted by his wife Srimati Rashmi Chaturvedi, who is also present today in this forum. We would like to welcome her also. In order to listen, now I request directly to the speaker to come on the stage and please enlighten us with the topic of constitutional law.
Honorable Mr. Samir Salam Sarmbalkar, I'm so sorry, it's little tongue twisting, Secretary of City Civil Court Bar, other dignitaries, on the dais, off the dais, my wonderful friend Anand Naik, Ghanshyam Mishra, Mr. Desai, and all my fellow lawyers. The topic given to me today deals with a very, very interesting aspect. Article 227 of the Constitution of India. Now, As we all are aware, that Chapter 5, Part 6 of the Constitution of India, I repeat, Chapter 5, Part 6 of the Constitution of India is titled as High Courts in the States, which begins from Article 214 and runs up to Article 231. Among these 18 articles, the most important are two articles. Article 226 and Article 227. 226, we all know, is a writ jurisdiction, prerogative writ jurisdiction of the High Court. But Article 227 is a supervisory jurisdiction of the High Court. Now, there is a lot of confusion among the bar, including the High Courts, benches across India, that what is the difference between 226 and 227? Now, the common practice is, we lawyers, when we are confused, we do not take the confusion on ourselves, we confuse the bench. That is our practice. So what we do is, we put writ petition under Article 226, read with 227 of the Constitution of India, let the High Court's office deal with it. That's their headache, we have put it, because we are confused. So that is why it seems Samir must have thought that let this confusion be clarified. What is 226 and what is, can I just add it over to you? What is 226 and what is 227? So let me tell you that although this Article 227 finds place in the Constitution of India, it is a historical provision. Much earlier than the Constitution of India. It is way back in 1861, during the British era, High Courts Act of 1861 was promulgated. And under High Courts Act of 1861, Section 15 is ipso facto identical to Article 227. So since 1861 this provision is there. It's a historical importance. Now 1861 High Court Act, Section 15 was replicated in Government of India Act 1915, under Section 107. When the Government of India Act 1915 was promulgated, Section 15 of High Courts Act 1861 was replicated here in the Government of India Act. And then came the mother of the Constitution of India, that is Government of India Act of 1935. Because if you read Government of India Act 1935, you will find that the major portion of the Constitution of India is borrowed from Government of India Act 1935. And Article 224 of the Government of India Act 1935 replicated Section 15 of 1861 and 107 of 1915. But there was a mischief played in 1935 Act. And that was, when you read 1935 Act, you will be able to understand what was the mischief. Article 224 added subclause 2 in the Government of India Act 1935. And what was that subclause 2? That subclause 2 snatched away the judicial superintendence of the High Court. That means Section 224 of the Government of India Act, by subsection 2, left the High Court with only administrative superintendence. Subsection 2 said that the High Court, notwithstanding whatever in the subclause 1, High Court does not have the judicial superintendence over the subordinate courts. This mischief was there by the Britishers, which was fortunately, while drafting the Constitution of India, under the chairmanship of Dr. Baba Saheb Ambedkar, he had the brilliance to catch this subclause 2, that this is mischievous. And therefore, that subclause 2 was deleted. So when that 224 was replicated as 227 in the Constitution of India, that subclause 2 was removed. So what remains today? Article 227, although is silent, it does not talk about judicial supremacy. It does not talk about judicial supervisory or superintendence. But because that subclause 2 is removed, our high courts have assumed that power. And therefore, 227, though titled as supervisory jurisdiction, carries on with the judicial superintendence also, although it does not speak in the open terms. So what, as on today, 227 speaks? It says that High Court shall have superintendence over all the subordinate courts, including tribunals within its jurisdiction. Subclause 2 of Article 227 states that what is the meaning. So subclause 2 explains it, saying that by supervisory jurisdiction, including judicial supremacy, the High Court can call for the returns. Returns means records of the subordinate courts. The High Court can call for the records of from the subordinate courts or tribunals. Number 2, 227 gives the power to the High Court that within the area of its own jurisdiction, the High Court can make rules for the practice and proceedings. So what do you read and follow civil manual and criminal manual here? That power is driven under Article 227 when the High Court formulates these rules of practice, including if I am not audible, please Tell me.
Your voice is audible.
Okay.
Like it sound good.
Yeah, please. Let me know if I am not audible.
No, here you are audible.
Yeah.
But there are people here that room also.
Oh, I'll take care. So, Article 227 states subclause 2 has 3 portions. First, the High Court can call for records from the subordinate court. Number 2, the High Court can make rules including forms for practice and proceedings. And number 3, A, B, C, subclause 2. The third is that the High Court can prescribe for a table of fees which is to be charged by sheriff, by clerks, by officers, by attorneys, by advocates, and by pleaders. How many categories? 6. Table of fees of 6 categories High Court can prescribe. Now here I pause for a moment. Because this table of fees have 6 categories: sheriff, clerk, officer, attorney, advocates, and pleaders. Which advocate follows this table of fees today? We all know that that's such a figure which cannot afford you a cup of tea or a piece of pan in the whole day. But why that table of fees is important then? It's a very vital role, and that is the reason I'm telling you that although it's a very, very nominal figure, and if you read that, you will laugh. You will foo-foo it. You will mock it. मेरे ट्रेन का पास भी इससे महंगा है. मैं कोर्ट पहुंचूंगा ही नहीं तो टेबल फीस लूंगा कैसे? लेकिन फिर भी वो टेबल ऑफ फीस is important because when the costs are imposed on your suit, on your application being rejected, there are certain times suit dismissed with costs, isn't it? All of you must have experienced. Do you know how that costs are calculated? That table of fees. And that is why we all happily pay the costs. Achha, cost lagaya, koi baat. Because that is so funny to you that the costs chart. Do you know the office of every court prepares the bill of costs, because judge only passes an order one line, the suit is dismissed with costs, or the petition is dismissed with costs. Judge is not bothered what is the cost. The job of calculating the bill of cost is from the office. And what does the office do? It falls back upon the table of fee prepared by the High Court under Article 227, subclause 2, subclause C. And highest advocate fee I have come across in that table of fee for the advocate, where I lost some suit and the cost is imposed upon our clients. Do you know how exorbitant that cost was? 45 rupees. The client did not even grudge. He did not even bother and come to say. Otherwise, had it been 45,000, he would have said, "Kya saab, dubo diya." 45 he happily said, "Fikar nahi saab, apan appeal mein jaye." I said, फिकर नहीं, वहाँ भी cost लगवाएंगे, वो भी 50 रुपए होगी. Because that's not beyond that, it's table of fees. Why I'm telling you is that that table of fees is important. You may be charging whatever, but when it comes to calculation of costs, that table of fees is important. When you pay for the process fee or for the summons to be served, you to pay bailiff fee through sheriff, that table of fees comes for your rescue. Thereafter, this is subclause 3, table of fees. Subclause 2, subclause A, B and C. C is, yes, one more aspect. C is, High Court is entitled to prescribe for forms for the entry of books, accounts prepared by the staff of the court. So whatever accounts, books are maintained, that forms are also prescribed by the High Court. And subclause 4 says that notwithstanding whatever is stated in provisions 2 and 3 of Article 227, 227 does not apply on armed forces tribunal. Whatever the tribunals have been formed under Defence of India Act or Armed Forces, 227 does not apply there. So that is an exception under subclause 4 of 227. Now the interesting part to understand that 227 applies both on civil proceedings as well as on criminal proceedings. Like I said, the petitions made under civil proceedings, generally what people do is writ petition under Article 226 read with 227 of the Constitution of India. Similarly, normally people file petition under 482 of CRPC for quashing of the FIR. But for your knowledge, 227 comes for your rescue there also. Because 482 is a statutory power, whereas 227 is a constitutional power. So I will tell you interesting story. 1947, when the country was getting liberated, in Himachal Pradesh, Amarnath had a shop, and Varyam Singh went to take that shop on tenancy. Annual tenancy agreement at the rate of rupees 175 per annum rent, this agreement was executed. And that agreement had a clause of renewal after the lapse of 1 year. That if the tenant wants to continue in the shop, he can renew the tenancy agreement. Varyam Singh, who was the tenant, did not bother to renew the tenancy agreement but continued in the possession. So 1948 and 1949, 2 years rent became due. He remained in possession, neither renewed the agreement nor paid the rent. So Amarnath filed a suit for eviction for the arrears of rent, on the ground of arrears of rent. The court below issued notices to Varyam Singh, who immediately paid 2 years rent of 1948 and 49 in the court. The suit was dismissed. because the ground for arrears of rent is met with. All the arrears are deposited, the suit is dismissed. But what Amarnath forgot to continue in the possession in the year 1950 as well and did not pay the rent again. So a fresh suit was brought for eviction. Varyam Singh did not pay the rent for 1950 also. A fresh suit came to be filed. Now this Varyam Singh must have been advised by some very good lawyer. So what he did is, when he received the second suit for eviction, this time instead of depositing the rent, he made an application for fixation of the fair rent, saying that 175 rupees per annum is too huge, an exorbitant rent. So the fixation of fair rent must be done by the court. This second suit of eviction is dismissed on the ground that fixation of fair rent application is pending until the fair rent is decided. There cannot be arrears because it is not fixed as yet. Amarnath felt cheated, went to appeal. Appeal was dismissed. That yes, lower court is right. So he filed a 227 petition. Now, as I said, this was Himachal Pradesh, and Court of Judicial Commissioner was having the power of the High Court, who considered this 227 petition, issued notices and set aside the lower court's judgment as well as the appellate court's judgment and directed that the possession be handed over to Amarnath, who is the owner. This time, Varyam Singh felt cheated. So Varyam Singh went and filed an SLP before the Supreme Court of India, stating that Article 227 of the Constitution of India does not give the power to go into the facts of the case and set aside that judgment. And ladies and gentlemen, this is a landmark judgment of Varyam Singh versus Amarnath, 1954 Supreme Court, where the Supreme Court upheld High Court's judgment. High Court means Judicial Commissioner's judgment, stating that High Court was within its parameters to set aside both the lower subordinate courts' judgments on the ground which does not stand. And we all know today that that ground does not stand. That somebody has moved an application post filing of a suit does not give a defense to the suit. It is in Varyam Singh's judgment of 1954 Supreme Court. The Supreme Court laid down certain parameters. So, 1954 itself, 227 clarification began. And the Supreme Court held that it is true that under Article 227, the High Court cannot go into the facts of the matter. High Court cannot assume appellate or revisional jurisdiction under Article 227. Because appellate jurisdiction are separate, revisional jurisdiction are separate, and supervisory jurisdiction is separate. And this was confirmed, this view of Supreme Court was confirmed by catena of judgments of Supreme Court, including Chandrasekhar Singh versus Siaram Singh, 1979 Supreme Court. Then Umaji Keshav versus Radhika Bai, 1986 Supreme Court. And as late as 2003, when two landmark judgments came. One was State through Special Cell New Delhi versus Navjot Sandhu alias Afshan Guru, 2003 Supreme Court. And another very important landmark judgment to give a clarification of 227, Suryadev Singh versus Suryadev Rai versus Ramchandra Rai, 2003 Supreme Court, where the Supreme Court laid down the parameters, clarifying that although, unlike the High Courts of England, High Court of India, under Article 226 and 227, appears to be quite similar. That is the reason of confusion. They are quite similar because, as I said, 1935 Act, subclause 2 is removed. So even judicial superintendence is assumed by High Court under Article 227. 226, prerogative writs. And if you remember 226, it is wider than Article 32 of the Constitution of India. The powers of the Supreme Court are under Article 32 to give prerogative writs. But the Supreme Court power under Article 32 is lesser than Article 226 power given to High Courts, because here the writs can be issued against the violation of Part 3 of the Constitution, that is fundamental rights. And Article 226 reads further, and any other violation of law, which is missing in Article 32. So Article 32 limits up to violation of fundamental rights. 226 says violation of fundamental rights or any other rights given under law. So that widens the scope of 226. Further, Article 226, the High Court can issue a writ against a person, authority, or the government, which is again a wider provision. But we are not talking of 226 today, some other day. I am just giving a correlation so that you understand the value of 227 vis-a-vis 226. Because 227 has to be compared with 226, then only to be understood about this clarification. Because there is no watertight clarification. So I'll give you certain bifurcations for simple understanding of yours. That where and what are the limitations of 226 and where and what are the limitations of 227. Where the 227 applies and where 226. Now the primary difference between 226 and 227 is that under Article 226, the High Court has the power to issue certiorari, among other writs. I am just taking certiorari. Certiorari means to quash and set aside the order passed by any governmental authority or subordinate court. person, authority, violating the right of the litigant. That's it. The High Court cannot go beyond it. If you disclose that the order passed by the subordinate court or tribunal is in flagrant disregard of the provisions of law, the High Court can quash and set aside. But under Article 227, the High Court can go further. It can quash and set aside, and additionally can do two more things. If you could succeed to satisfy High Court, the High Court can issue directions to the subordinate court to consider the suit or the application or the petition afresh, which under Article 226 the High Court cannot do. It is only under Article 227 the High Court can set aside, quash the order and give directions to the court below to consider the proceedings afresh. One step further, the power under Article 227 the court has. Not only this afresh, if you could further succeed to satisfy High Court, it can substitute an order passed by itself as against the order of the subordinate court, which under Article 226 the High Court cannot do. That means, instead of remanding the matter back to the lower court, the High Court itself can pass a fresh order and substitute the subordinate court's judgment. It can simply say that, forget that judgment, I am passing that this is final. This is the widest power provision only under Article 227 of the Constitution. To substitute a judgment in place of the lower court's judgment, which is not there. So in case, as a practicing lawyer, if you want that my case is very vital, very important, and my client is unnecessarily suffering, the matter or the relief will be further delayed if the matter is remanded back and considered afresh. You can convince the High Court that please pass an order here itself, so that this rigmarole to go back and go into the roller coaster ride once again can be avoided. And if the High Court is satisfied, it can do so. In Suryadev Singh's judgment, the High Court, the Supreme Court has held that under supervisory jurisdiction, even if you don't file a petition, if the High Court finds that this is a flagrant disregard of the provisions of law, a suo motu orders can be passed by the High Court under Article 227. Whether you are aggrieved or not aggrieved, High Court under administrative jurisdiction has felt that the subordinate court is going beyond the jurisdiction. And normally 227 now came into prominence after 2002. Because prior to 2002, if you all remember, if you had practiced but prior to 2002, you must be remembering there was a provision under CPC, Section 115, which talked about civil revision. And invariably civil revisions were filed, blaming that three grounds. Civil revisions were there. If the subordinate court has exceeded its jurisdiction, if the subordinate court does not have jurisdiction, if the subordinate court does have jurisdiction but did not use it, Three jurisdictional issues the entire civil revision used to play around. That still goes on. But what happened on 1st July 2002, a landmark date, with effect from when the amendment to CPC 1999 came into force, 1st July 2002. Civil revision doors were shut against interlocutory orders. Today, against an interlocutory order, you cannot file civil revision because 2002 amendment shuts the door. But what doors were shut by amendment to CPC opened up 227. We lawyers are very innovative. You shut the door of a statutory provision, we will open a constitutional provision. And you can't shut constitutional provision. So, high courts were flooded with 227 petition against all the interlocutory orders. And the grounds were same. The subordinate court has exceeded jurisdiction. The subordinate court, having jurisdiction, did not use it. And the subordinate court overstepped. On these grounds, High Court is flooded with 227 today. So what fun the amendment committee had by shutting the door of a statutory provision? Doesn't make a difference to practicing lawyers. We find another way. Like a water canal, if you stop from here, it will turn and go from there. It doesn't stop, isn't it? Now, in Afshan Sandhu, that Afshan Guru matter, 2003 Supreme Court, the Supreme Court held that while considering 227, the High Court must be aware of three parameters. One, that it should be used sparingly. Number two, that in the disguise of correcting the error, the High Court should not assume and wear the cloak of appellate jurisdiction. It is purely supervisory jurisdiction, not the appellate jurisdiction. So High Court is not sitting in appeal to the subordinate court's order. The High Court must remember this. And third, which again created a confusion, that under Article 227, the High Court is not empowered to correct the errors of the subordinate court judgment. Now, if errors cannot be corrected, what is the purpose of 227? So there a clarification came. No. We meant two further things came. High Court, Supreme Court clarified in Suryadev Singh that what we meant is the factual error the High Court cannot do. But if the error is apparent on the face of record, a flagrant disregard of the provision of law, and number two, if it is resulting into injustice to the litigant. Now, every litigant feels injustice is met. So the doors are again wide open, isn't it? So Supreme Court tried to put some curb, but then said no, it can't be done. So it said, Alright, two things. If the error is apparent on record, flagrant disregard of principles of natural justice, and if it is resulting into unfairness or injustice to the litigant. Now, we lawyers just need a slight margin. We are innovative enough to bring it into that category that this is flagrant disregard. This is absolute unfairness. And every petition has it. Isn't it? So what was shut by CPC was substituted by 227. And as I said, that 227 applies not only on the civil side but the criminal side also. So Chandrasekhar Singh versus Siaram Singh, 1979 Supreme Court is a glaring example of it. I'll just give you a story in nutshell. Chandrasekhar Singh, that criminal part. Because 227 applies on criminal proceedings also. Now Chandrasekhar Singh and Siaram Singh fought over a same piece of land. And the police captured the land, reported it to magistrate, and 145 CRPC proceedings were initiated. We all are aware. Property dispute, 145 CRPC applies. Although I am talking of prior to 1973 CRPC, but because the 79 judgment, actually action was prior to 73. Judgment came in 79 by the Supreme Court. So 145 proceedings were initiated by the magistrate, where the dispute was so aggressive by both the sides. Chandrasekhar was also aggressive and Siaram was also aggressive, that the magistrate could not understand who is in possession, and both of them claimed that we are in possession. So magistrate, finding itself difficult to find out whose claim is right and whose claim is wrong, referred the matter to civil court, sent a reference that kindly find out who is in possession. Right? So a reference was made to civil court by the magistrate. Civil court, on the basis of documents filed by both the sides and affidavits filed by their relatives and friends and all that, no, my friend is in possession, they said my relative is in possession. So, civil court again was flooded with documents contrary to each other. But civil court, minutely observing the documents and affidavits, came to the conclusion that Siaram is under the possession of the property, and sent its findings back to magistrate, who had sent the reference. So the reference with the findings was sent back to magistrate, who on the basis of this findings of the civil court passed the judgment in the favor of Siaram. That the civil court has found him into the possession and his claim is stronger than Chandrasekhar. So the magistrate passed the order on the basis of the findings of civil court. Chandrasekhar was naturally aggrieved, who is not in India. In India, do you know why we lawyers are flourishing? Because we have a psychology of being dissatisfied. Every litigant is dissatisfied. ऐसा कभी होता ही नहीं कि किसी ने बट इन ऑल ह्यूमिलिटी एक्सेप्टेड द जजमेंट. नो 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 सर, दिस इज रॉन्ग. हाउ कैन दिस ऑर्डर बी पास्ड? एंड डू यू नो व्हाट इज द ऑफ्ट रिपीटेड रिमार्क्स वी लॉयर्स हियर? ये जज मिल गया है, इसने पैसा खाया है. ये पहला रिमार्क होता है. कभी कभी लॉयर भी मिल गया है. ये सब हमारे जजेस को रोज सर्टिफिकेट मिलता रहता है, लॉयर्स को भी मिलता रहता है. इसीलिए बीच में किसी ऑर्गेनाइजेशन ने मुझे एक, आई एम जस्ट गोइंग सिंपल अवे फ्रॉम दिस लॉ टॉपिक, किसी ऑर्गेनाइजेशन ने मुझे फोन किया और मेरी कंसेंट मांगी कि सर हम आपका सम्मान करना चाहते हैं, आपकी कंसेंट चाहिए. थोड़ी देर तो मैं फोन पास में करके देखता रहा कि ये कौन आदमी है. फिर मैंने कहा भाई साहब ये मजाक है क्या? तो बोले नहीं नहीं सर सीरियस है, हम आपका सम्मान करना चाहते हैं, उसके लिए कंसेंट. मैंने कहा ऐसी चीजों के लिए कोई कंसेंट मांगता है? ये कौन सी प्रैक्टिस है? मैंने कहा भाई साहब इससे पहले कि आप अपना मन बदल लें, मैं आपको कंसेंट दे रहा हूं, आप कहिए तो राइटिंग में भेजता हूं, आप मेरा सम्मान कर डालिए, क्योंकि मेरा बचपन से आज तक सिर्फ अपमान ही हुआ है, सम्मान तो कहीं हुआ ही नहीं. लॉयर बनते ही सिर्फ अपमान हो रहा है. कोर्ट में जजेस अपमान करते हैं, कोर्ट के बाहर आके गैलरी में क्लाइंट अपमान करते हैं, घर पहुंचो तो श्रीमती जी अपमान करती हैं. तो हमारा सम्मान का आपने क्या देख के मेरा ये सम्मान करना चाहा है? और कर ही रहे तो कंसेंट क्यों मांग रहे हैं? भैया कर डालो. और आपके पास ऑडियंस ना हो तो मैं लेके आऊंगा, सबको दिखाऊंगा कि देखो मेरा सम्मान भी हो रहा है. अभी देखो आज समीर जी ने भी गुलदस्ता दे दिया है, थोड़ा अच्छा लगा. जाते वक्त कार में बैठते ही वाइफ को दे दूंगा. थैंक यू समीर. सो दिस Chandrasekhar was also displeased, not happy with this judgment. That how can the court decide on the basis of civil court findings that I am not into possession? But the problem arose here. What to challenge? The problem is whether to challenge the magistrate court's order or the civil court's findings, and where to challenge, because this is a wonderful clubbing of civil as well as criminal. तो वकील साहब परेशान हो गए, सीपीसी लगाऊं कि सीआरपीसी लगाऊं, जाऊं तो जाऊं कहां? तो रेस्क्यू में कौन आया? योर्स ट्रूली 227. भाई कॉन्स्टिट्यूशन तो है, सीपीसी लगे ना लगे, सीआरपीसी न लगे, कॉन्स्टिट्यूशन तो दोनों पे लग रहा है. 227 तो काम आ रहा है. सो 227 petition was filed. And unfortunately, now those provisions are not there. In CRPC of 1898, section 435 and 439 prohibited the reference to be reviewed. Now, reference, as we all know, is between courts. How can you challenge a reference? You can't file an appeal. You can't file a revision. You can't file a review. You're stuck. So finally, magistrate's order was challenged that this is based on the wrong findings. Here again 227 had restrictions that it cannot go into the facts of the case. Isn't it? I just now told you. So 227 bhi atak gaya. How can 227, the High Court, go into the facts of the case? Unless there is two things which I told you. Flagrant disregard of the provisions of law. Apparent. Do you know what is the meaning of apparent? Which need not to be demonstrated. It is res ipsa loquitur, speaking in itself. Right? So therefore, there was no factual error apparent, and the other ground is that if it's absolute, unfair, or leading to injustice, which a factual thing cannot be. I mean, what did a finding on the basis of documents? The ground by Chandrasekhar was that the court did not consider affidavits. It only considered other documents, which the court disregarded. That cannot be a ground. And the matter went up to Supreme Court. In the SLP, the Supreme Court upheld High Court, stating that the High Court is right. So, what I was telling you is that 227 is not limited to civil side, but also criminal side, and that is why I gave you this example of criminal proceedings also. So, whenever you are invoking 227 besides 482 CRPC, you must be clear that you must see whether it is fitting into the parameters or not. It is a different story that you are met with a counterpart who has not done that much research. So that's good for you. But that does not mean that you do not research on your brief. You must be prepared, ready to answer, because these are the vital provisions. And a clearly enunciated provisions. And that is why I bifurcated 227 to you, the actual constitutional provision, then the landmark judgments, vis-a-vis 115 of the civil revision provision, which is now amended, interlocutory is away. 227, you can challenge even an interlocutory order, and also the criminal part. As far as 226 prerogative writs are concerned, that is limited to original jurisdiction of the High Court. But 227 applies where, although Supreme Court in these category of judgments says that the High Court cannot wear the cloak of appellate jurisdiction, but under supervisory jurisdiction, and because subclause 2 of 1935 Act is removed, the High Courts are doing judicial supremacy under Article 227 also. So if you can convince High Court, you can utilize what 226 cannot come for your help, 227 can come for your help, and can get you the relief to your client and whatever desired way you want. There are these minutes which you remember. I'll just sum it up in a nutshell. First, the Supreme Court has held that 227 should be invoked by the High Courts sparingly, not routinely. Number two, the High Courts must not wear the cloak in disguise and assume the appellate and revisional jurisdiction under Article 227. Next, High Courts must be aware that 227 is different from the prerogative writ jurisdiction where the certiorari quashing the subordinate courts' judgments and subordinate authorities, government authorities' judgments can be quashed. Under 227, if there is a flagrant disregard resulting into unfairness, the High Court can not only quash and set aside the subordinate court's judgment, but substitute it with its own judgment or remand it back for considering afresh. Another important feature to remember, that even if you are not aggrieved, High Court finds some flagrant disregard, the High Court can suo motu issue supervisory jurisdiction notices under 227. Another important feature to remember is under Article 227, the High Courts have to see whether the petitioner has alternative efficacious remedy or not. If you have alternative and efficacious remedy, the High Court can turn down your 227 and say that why have you not invoked that remedy. So these are some of the vital parameters laid down by several judgments of the High Courts, which over the years, when you keep practicing, they become part of you. And you can enumerate that your petition must be fitting into those parameters or not. And if you are willing to challenge a subordinate court's judgment or a tribunal's judgment or a governmental authority, under Article 227, my advice to you all practicing lawyers is that please test your petition on these parameters, and I'm sure you will succeed. At least your petition will not be rejected on technicalities. It's a different story if you are rejected on merits. That's a different story. But on technicalities, it doesn't behove good to a lawyer that the lawyer is stuck on a technical legal provision. So that can be of great help to you. I hope you have some level of satisfaction as far as 227 is concerned. If you have any questions, I'm here. You can ask a question. Otherwise, thank you very much. Jai Hind.
Any questions?
Yes. You want a mic?
Sir, 227 और आफ्टर रिवीजन जो आया मेरे उसमें डिफरेंस क्या है? उसमें भी हम फैक्ट पे नहीं जाते, रिवीजन जो बोलते हैं, और 227 में फैक्ट पे नहीं जाते। ओनली फॉर सुपरविजन तो लीगल इंजरी जो भी है उनके हम फैक्ट पे बात करते हैं। फिर ऐसे सिचुएशन में हम रिवीजन फाइल करना वो बेटर है या 227 पे फाइल करना?
क्या शुभ नाम आपका?
पवन
पवन
सर।
Pavan Kumar ji has asked the question that what is the difference, and if one is confused whether to file civil revision or 227. पवन कुमार जी, आप कहाँ बैठे थे? जग रहे थे ना कि सो गए थे? I made a clarification that after 1st July 2002, civil revision cannot be filed and against interlocutory orders, whereas 227 can challenge interlocutory order which is against you. Otherwise, civil revision is filed on the basis of violation of jurisdictions. As I told you, 3 types of jurisdiction, and same as 227. But 227 can be filed against an interlocutory order. Civil revision can be filed only against the final order. Got it clear? Okay. And yeah, please.
Sir, suppose same suit, suppose one of the suit XYZ.
Get that water. Ji.
XYZ. Number of order is passed. Can be challenged one with under 227. High order can be challenged the same person.
Come again, come again.
Sir, एक suit में या एक interlocutory order हुआ है. Interlocutory order में समझो सब 4-5 order एक ही same judge, same party के साथ. वो 227 में वो 5 order एक साथ हम challenge कर सकते हैं.
Why not? Of course, yes. Of course, yes. If they are passed on the same petition and on the same date, you can annex that all these petitions, all these orders are violation of the provisions of law. You can file it.
Because the separate order is separate act.
Correct, but you can also exhibit it in your averments, na, that this order dated such and such is exhibit this order dated such and such on point of this is exhibit second. And in the prayer clause, you can say that exhibit X to exhibit Z are all violative of my rights and they should be set aside. Why not? You can file it. I hope it has satisfied you.
Sir, because मैं question और पूछा था 9 बिल का सर 9 बिल का जो जजमेंट है जो 1971 में जो आया उस जगह पे 226 को जुडिशियल ऑर्डर को हम नहीं मानते हैं कि सेक्रेटरी ने आया.
That is true.
And now it is after in the judgment 2003 में जो आया ये कुमार देवी का जो जजमेंट 2003 and 2015 उसको बाय करके कि नहीं आपको 26 में भी आप जुडिशियल ऑर्डर को भी चैलेंज कर सकते.
So what is your question?
क्वेश्चन इज इस 9 बेंच को फॉलो करें जब 2015 में 3 बेंच का देखो तो
Earlier provision of 9 benches judgment still holds good because if you read the original provision under Article 226, the scheme of the Constitution, I'll just go slightly back so that you can understand the provision. And for all of you, it's a very good question raised by Pavan Kumar. Pavan Kumar is saying that can the Supreme Court be invoked under prerogative writ jurisdiction against a High Court order? Now, if you read the Constitution of India, the Constitution of India applies the writ jurisdiction whether under Article 32 or 226 only against executive and to some extent against legislative, because there are 3 limbs of power: legislature, Pavan Kumar, executive and judiciary. Prerogative writs do not apply on judiciary. So, just for your clarification and through you to all of you, that in our constitutional scheme, high courts in no way are inferior to Supreme Court, except the administrative area. So if you have this misconception, remove it today. According to our Constitution of India, High Courts are not inferior to Supreme Court as far as judicial area is concerned. So if a writ under 226 is passed by the High Court, the Supreme Court cannot quash that writ under Article 32 because that's a judicial order. There a writ cannot apply. Writs are applied only against executive and to some extent against legislative when ultra-virus provisions are held by the Supreme Court or High Court. That is against legislature. That you cannot frame a law beyond the constitutional provisions. But if you invoke 32 against 226, Supreme Court will throw it in the dustbin. Judicial orders cannot be, so that is a settled principle by the constitutional provisions itself. I hope that answers your question, Pavan Kumar. Any other question? Yes. You want a mic? Because I am happy you all are asking intelligent questions, let all be listening to that.
आपण असं म्हणाला की अल्टरनेट रेव्हेन्यू जर असेल तर 227 खाली जाऊ शकत नाही असं आपलं एक डिफेन्स आहे असं आपलं एक क्लॉज आहे माझं असं म्हणणं आहे सीबीसी मध्ये प्रोव्हिजन अशी आहे 40.23 खाली रिमाइंड करू शकतो मॅटर 40.27 खाली आपण ऍडिशनल एव्हिडन्स घेऊ शकतो 151 खाली प्रत्येक कोर्टाला इनहेरंट पॉवर आहे
Inherent powers.
बरोबर आहे मग आता ह्या सर्व पॉवर्स असताना सुद्धा अल्टरनेट रेमेडी कुठे आहे हा पहिला प्रश्न दूसरा प्रश्न तो आपण 145 सीआरपीसीचा सांगितला 145 ला तुम्ही असं सांगितलं की त्याची ती सिमिलर प्रोव्हिजन आहे 482 खाली हायकोर्टामध्ये इनहेरंट प्रोव्हिजन इनहेरंट पॉवर्स 482 खाली आहे पण त्याच्यामध्ये माझा असा प्रश्न आहे की जेव्हा हायकोर्टमध्ये आपण जातो तेव्हा 482 ला सबस्टिट्यूट पॉवर 397 सीआरपीसी मध्ये आहे तो प्रत्येक ठिकाणी 482 ला 397 आहे अल्टरनेट रेमेडीला 40.23 आहे 40.27 आहे मग अल्टरनेट रेमेडी राहिली कुठे
Very good question. What's your name?
संतोष बोरकर
Santosh has asked a very good question. I hope you have understood the question, or let me repeat it so that you can understand. He says, what is the meaning of alternative remedy when things are overlapping? He says CPC has alternative remedies, CRPC has alternative remedies, 482 vis-a-vis 397. He says CPC has remedy, order 41, 27 is for additional evidence, and 151 is inherent powers. Let me tell you. Order 41 is appeal. If you have a provision of appeal given by the statute, this is Santosh's an alternative remedy. Court says, why are you coming under? Similarly, under CRPC, the statute provides criminal revision. Statute provides inherent. Why are you coming and bothering us under writ jurisdiction? So, Santosh, the scheme of statutory powers versus constitutional power is the battle. And because the constitutional powers are ultimate, it is in a way the high courts help you by returning to go back and invoke your statutory provisions, because thereafter, if your alternative remedies are exhausted and you are not satisfied, this constitutional remedy remains. But if the constitutional remedy directly is invoked and rejected, you cannot go back to your statutory provision because they are inferior provisions, subordinate provisions, statutory provisions against the constitutional provision cannot be. So that is why, although it is also true that our high courts are flooded with litigation, they are overburdened and they say, "Bhai, why are you bothering us? You have the provision. Go and invoke it." But the truth is that when they are sending you back, they are actually doing you a favor because your multiple tiers of relief are available to you. So that is why, if I recall, Supreme Court in the Whirlpool judgment has held that this alternative remedy is not sacrosanct. So if the courts find on the basis of your petition that there is gravest error happening, it is so apparent that it cannot be sidelined on the ground of alternative remedy, then despite alternative remedies, the petitions are entertained. But it depends on the merit of your case. But in general, it is advisable to invoke alternative remedy. Do not rush to constitutional remedy. As a lawyer, you would be doing better service to your client by giving him the right advice that statute gives you this relief, invoke it, and if it is rejected, we still have this constitutional remedy. I hope that answers your question, Santosh. I'm sorry, sir. अरे मेरा क्या, समीर का परमिशन आपके और मेरे दोनों के सेक्रेटरी यही है.
ज्युडिशियल रिव्ह्यू ही कन्सेप्ट आहे की 226 खाली येते का 227 खाली.
जुडिशियल रिव्यू की तो लंबी स्टोरी है. समीर जी से प्रार्थना करूंगा किसी दिन जुडिशियल रिव्यू पर ही एक स्पीच रख दो आप. इट्स अ डिफरेंट, बिकॉज मैं आपको जुडिशियल रिव्यू की कहानी सुनाऊंगा अगर, तो ओरिजिनल कॉन्स्टिट्यूशन ऑफ इंडिया 1950 में जब प्रोमलगेट हुआ तो 8 ही शेड्यूल थे, 9वां शेड्यूल ही नहीं था. और 9वां शेड्यूल जुडिशियल रिव्यू को सुपरसीड करने के लिए लाया गया, वेयर द पार्लियामेंट थॉट दैट ये सुप्रीम कोर्ट कुछ ज्यादा ही इंटरफियर कर रहा है, इसके विंग्स को काटना पड़ेगा, और इसलिए शेड्यूल 9 जोड़ा. और व्हाट आर द प्रोविजंस एडेड, that whichever statute is placed under schedule 9 is beyond judicial review. पर हमारे कोर्ट्स भी कोई कम नहीं. This is a very, very interesting battle, and there is a period which was, this battle was really in supremacy from, if you remember, 1970 up to 1980, Minerva Mills, beginning from this ADM Jabalpur versus Shivakant Shukla, Menaka Gandhi, then Kesavananda Bharati, and these all landmark judgments are very interesting read. They will, if someday the time permits, we will hold this session, one session only on this judicial review, where I will demonstrate that Vaman Rao's judgment, several such judgments which there is a battle going on. From Golaknath, the Supreme Court said that the Parliament doesn't have power to amend fundamental rights. The Parliament superseded Golaknath and brought amendments to the Constitution of India, which was again challenged under Kesavananda Bharati. And the theory of doctrine of basic structure was So संतोष जी, बहुत इंटरेस्टिंग एस्पेक्ट है जुडिशियल रिव्यू का, we will talk. But I just gave you a glimpse. The judicial review happens anyway. Any other question? Yes.
The read lies on the original 227. Which type of read lies? As you said, under 227, whether read lies on the original site and which type of read lies?
No. 227 never. Oh no.
Alright, because considering all this, they all lie on the accurate side.
Original site is only 226. Original jurisdiction 227 does not go into original site.
All on accurate side.
Yes, of course, yes. Yes. Yeah. SHRI. See, what's your name? Manjiri. Now Manjiri says that what is SHRI? Manjiri, if you read Hosbury's Laws of England, vis-a-vis Webster, what is the meaning of SHRI? We all are flummoxed. Because it is not English. One can understand Hindi, Marathi, English. बहुत हिम्मत हुई तो थोड़ी संस्कृत. अभी ये साला लैटिन टर्म आ गया. I'm sorry. SHRI is a Latin term. But if you convert it into English, it is basically certificate of the king. SHRI emerges out of the word certificate of king. Basically, these 5 writs which you find are issued originally by King's Court, which are borrowed in our constitution. So there are 5 writs: mandamus, certiorari, prohibition, quo warranto, and habeas corpus. So certiorari is like if a subordinate court passes an order which cannot be certified by the High Court, which is a higher court, equivalent to King's Court. So it does not qualify as being certified. So it is quashed and set aside. And that is where the result has happened is that when you file a writ of certiorari, that does it qualify to be certified by the High Court? See this order. And if the High Court finds that no, it cannot be certified, it quashes. That is writ of certiorari. I hope it answers you, Manjiri. Any other question? That's it. पवन जी, अपन बाद में मिलेंगे. समीर जी की परमिशन नहीं है आपको. समीर जी से परमिशन लीजिए.
एक क्वेश्चन हो गया सर.
बोलिए, आपका मन अधूरा नहीं रहना चाहिए. See, I am not a High Court judge, so I am not quashing and satisfying your question. अरे बिल्कुल, मेरा सौभाग्य है. बोलिए. दोनों नहीं लिख सकते. अच्छा, ओके जी. देखिए, स्टेट ऑफ भजनलाल वर्सेस भजनलाल वर्सेस स्टेट ऑफ हरियाणा इज अ लैंडमार्क जजमेंट ऑन दैट पॉइंट. पर प्लीज आप ये बात समझिए, if you read that judgment, Bhajanlal versus State of Haryana, you will find that there were grounds where the fundamental rights were breached. But not in every quashing of FIR your fundamental rights are breached. If you are simpliciter going for quashing of FIR as well as quashing of the charge sheet, you have to just go under 482. The moment you will club it with 226, you have to cross the hurdle of the High Court's office first before reaching to my lords. So, according to me, unless you have a very, very exceptional case where your fundamental rights are breached, don't club it with 226. That is because Bhajanlal, if you read, there were justification and grounds where fundamental rights were breached. Any other? Oh, sorry, I'm not even giving an option. So thank you so much. One more thing before I leave. I just want to make an announcement to all of you that in case if you want to hear more such clarification and speeches of mine, you can log into YouTube. Just type my name, Puneet Chaturvedi Advocate. You can search it on YouTube. There are various such speeches on minutes of various provisions of law, CRPC, CPC, evidence, company law, and multiple such things. You can fall back upon it. And one more proud announcement that very soon one of my books will be in the market on media law, which also you can avail and find some help if you are practicing in that area. In any case, I thank once again to Samir and his associates, Anand Nayak, Mr. Desai, etc., to have invited me, to give me honor to address my fellow lawyers. We all are parallel, equal. Whenever you need any help, you can call me, and we also provide free of cost legal assistance to all lawyers. You can just mail your query to sccadvocates@gmail.com. Within 48 hours, that query will be satisfied to the best of our understanding from the office. And even if you are not satisfied by that, I repeat the email ID: S for Singapore, C for China, again C for China, advocates, scadvocates@gmail.com, and my number is 9821010059. If you are not satisfied with the written answer received through my office, you can personally call me, and all this will be absolutely free of cost to all my fellow lawyers, because we are in the profession for 122 years. It behoves us to help our bar grow. Thank you so much, Jai.
Thank you very much, sir. Now I will request Honorable Secretary to present the memento, which is for the court is going in 75th of year of. Therefore, we are celebrating that cause, and we are giving memento due to that. I must say that very good lecture is given by Mr. Puneet Chaturvedi ji. I just wanted to say that most of the queries have been answered by him, and as he said that he has provided email ID also and number also. We will provide that email ID number to the members, so that any queries they are having, they can immediately check that number and email ID. Thank you so much.